Good morning and welcome to the latest installment of Treasure Coast Business Disaster Relief Efforts, brought to you by the Virtual Business Recovery Center and the Corporate and Community Training Institute at Indian River State College. This webinar is sponsored by the Florida Small Business Development Center, hosted at IRSC, and the Economic Development Council of St. Lucie County. I encourage you to post any questions, suggestions, comments, or concerns in either the Q&A or chat area of this virtual meeting room. Both can be found on your Zoom taskbar. Today, we're answering your questions about COVID-19 and the Fair Labor Standards Act with CCTI instructor, Thom Epsky. Thank you for joining us today, Thom. I'll now turn it over to you.
Thank you very much. I'll go ahead and share my screen. Can you guys see it? There we go. Well, thank you very much, Katie. Appreciate it. And I'd like to welcome everybody who's attending today. Today's webinar is hosted by the Virtual Business Recovery Center and our partners, the St. Lucie Economic Development Council, Indian River State College, and our local Small Business Development Center. My name is Thom Epsky. I have the honor of serving the citizens of Florida as a commissioner on the Florida Reemployment Assistance Appeals Commission. The commission harassment and discrimination, or if an employer has made a unilateral and material change in the workplace. We also deal with issues surrounding today's topic, the Fair Labor Standards Act. So I think this is a very timely topic, especially in light of the COVID-19 issues surrounding employment in general. As Katie mentioned, I'm also an adjunct professor at Indian River State College, facilitating classes in human resources, management, and legal issues. So I want to thank everybody for attending today. And if you do have questions, I encourage you to go ahead and fill out those in the chat or Q&A section that you see at the bottom of your screen. So Fair Labor Standards Act, this is a complicated law for many employers. It was passed way back in 1938 as a response to the Great Depression. And essentially it establishes minimum wage, overtime pay, youth employment restrictions, and record-keeping standards that affect all full and part-time workers in the private sector and in the federal, state, and local government. The law was designed to protect workers and address conditions that burdened the American economy during the Great Depression. We see, for example, in the overtime provision that Congress wanted to punish employers at the time that were barring more people from gaining employment opportunities. So the punishment came in the form of, if you had a worker that was working over 40 hours, you had to start paying them premium pay at a rate of 1.5 times their regular wage. This was the hope to encourage employers to go ahead and hire more employees at straight time. A little complicated with issues surrounding our modern 21st day economy and paying people under the same laws that we had last century, over almost 100 years ago. So for an employer, one of the most important questions to start with the Fair Labor Standards Act is, who are your workers? This is an important question because as an employer, you have an ongoing obligation under the Fair Labor Standards Act to employees in light of taxation and benefits, and of course, overtime provisions. These same provisions do not extend to self-employed independent contractors. And therefore, we see many times employers try to classify a group of workers as an independent contractor versus an employee. I will tell you that South Florida in particular has a long history of leading the nation in wage and hour claims, um, investigating violations of an employer not meeting its obligation under the Fair Labor Standards Act. So it's very important that as an employer, we classify which workers are truly considered employees, which are covered under the wage and hour law, and which are independent contractors. So this analysis is something that is not very daunting. There's a lot of guidance to be able to help us determine which of our workers may be legitimately considered independent contractors and which must be considered employees. So again, independent contractors are not covered under the wage and hour law. Let's take a look at this analysis: employees versus independent contractors. The distinction between an employee who most likely receives a W-2 for tax reporting purposes and an independent contractor who generally is issued a Form 1099, this is not a philosophical or very apparent distinction sometimes. The idea of titles or labels or job descriptions for particular workers I have seen very often misleading, and therefore shouldn't necessarily be relied upon to determine a worker's classification. So just because somebody is paid on a W-2 or 1099, it is not definitive when considering a worker's classification. So how do we do this test? Well, the IRS and the Department of Labor issue some guidance through their decisions, and we have court decisions which further illustrate that generally a court or the Internal Revenue Service is going to look at three factors: behavioral control, financial control, and the relationship of the parties. So in terms of behavioral control, we generally look at the right to direct and control how workers do their jobs, the instruction and training that is given to an employee or worker. Financial controls often look at the business aspect of the worker's job and look at reimbursements for ordinary business and travel related expenses. And then we look at whether there's a long-term relationship, which generally is indicative of an employee-employer relationship as opposed to an independent contractor. So one of the things that we generally look at through court decisions, which is called common law, because there's no necessarily defined statute on this. Common law is where we go to guidance from the holdings of courts which have decided these matters. The distinction between an employee and an independent contractor. Employees are generally presumed to work exclusively for an employer hired by the employer, is subject to at-will employment, such as being able to be terminated with or without cause, or can quit without consequence. Work is more personal. An employee is paid on a salary basis or wages and reimbursed for expenses. The employer generally furnishes the tools and equipment and materials, whereas an independent contractor generally is one that sets their own hours and determines the order and sequence of work. Generally works for multiple employers, and the services are available to many. They hold themselves out there as a legitimately self-employed business person, pays an occupational tax to their local jurisdiction, generally works by the job, and hires and fires their own assistants as necessary, and is providing their own materials and equipment and tools to be able to effect the job. So when we look at employees versus independent contractors, under common law rules, anyone who performs services for you is your employee if you can control what will be done and how it will be done. And that's the clear distinction that many courts look at for guidance. This is so even when you give the employee freedom of action. What really matters is that you have the right to control the details of how the services are performed. Now, the IRS has given some further guidance, and one can easily find this by researching on the web the IRS 20-factor analysis. And essentially, these are 20 questions that help guide an employer. Is the individual's work vital to the company's core business? Did the employee get trained to perform tasks in a specific way? Did you as the employer instruct the individual as to when, where, and how the work is performed? So with those first three questions, activities that are integrated within the organization's business operation and are usually having workers that are taught the specific work procedures that they are expected to follow and must comply with are generally deemed for employees, whereas an independent contractor typically is limited to non-essential business activities and are generally considered experts in their field, and as such, they determine the work methods that are most appropriate. And additionally, they are typically held accountable only for their outcomes, not the means in which they are achieved. The order and sequence of work. Employees, again, are generally told with regard to these activities how they're going to be done, where an independent contractor generally chooses. Setting the hours of work. Employees, of course, are generally work on a schedule, and that's, in my experience, determined by the employer, where independent contractors can work whatever hours they choose, provided that there's an agreed upon deadline that's generally met. For an employee, services rendered personally. What we're talking about here is that employees must do the tasks for which they were hired themselves, where independent contractors are free to delegate to their own staff or subcontract the work to others. So independent contractors have much more flexibility in hiring, supervising, and paying their own assistants. I think many employers would probably be upset if they found out that some of their employees on their own started hiring assistants to do the job for which they were hired. Number 8, the permanency of the relationship is something that is generally looked at by the IRS and courts. Does the individual perform regular and continuous services? Employees, of course, typically have an open-ended relationship with a company, even if the work is performed at irregular intervals, whereas an independent contractor generally works on a project-by-project basis, each with a new contract. Continuing relationships move into the full-time requirement. So are you or your organization the sole or major source of income for the employee, the worker? Workers who are employees are usually expected to devote all of their working hours to their employer, whereas independent contractors don't spend so much time with any one company that they are restricted from doing projects for others, and in fact generally work for multiple clients concurrently. Where is the work done? So employees are ordinarily required to work on site. Independent contractors are free to work off-site, such as in a home office. Again, this becomes a little complicated in light of COVID-19 and work from home arrangements. So you can kind of see how the IRS and courts look at this, how we pay in a worker. Employees are usually paid at fixed intervals, where independent contractors are generally paid for their time when a result happens. not the amount of time that they've actually worked. Furnishing of tools. Again, employees generally are furnished their tools by the company, where independent contractors furnish their own. And so what an employer has to do is look at these 20 questions, and especially 19 and 20. 19 relates to the worker. Can the worker terminate? You know, is an employee able to quit at any time? Of course, you know, it's part of that at-will employment. Independent contractors are generally legally obligated to complete a project according to contractual terms and provisions. And that can only be dismissed if they fail to do so. Whereas an employer under at-will employment can regularly discharge somebody. So these are very fact-specific questions. Now, just because you have a worker who you classify as an independent contractor, you may find a question or two relates to what would normally be an employee. For example, you may have at your own home a long-standing relationship with somebody that comes and services your lawn and garden, a landscape company. Just because you may have had that person for 10 or 15 years doesn't mean that suddenly a court or the IRS is going to come in and say, due to the permanency of that relationship or longevity, you're now going to have to classify that that person as an employee. So the problem for most employers becomes when more of these 20 questions are answered affirmatively in favor of having an employee. It becomes less justifiable for an employer to classify that person as a legitimate independent contractor. All right, let's take a look then. Once we've analyzed our workforce and determined who, for example, has been an independent contractor and who's an employee, our next analysis becomes, is the legitimate employee exempt or non-exempt? Now, this is a difficult question for many employers. The distinction is important because exempt employees are excluded from the overtime provisions that are inherent in the Fair Labor Standards Act, where non-exempt employees are covered by the FLSA and must be paid a minimum wage and overtime. Now, in order to classify an employee as exempt, there's a very high bar. There are 3 prongs that need to be met. And just be aware, as an employer, the federal government's approach, the Department of Labor, the Wage and Hour Administration, wants to broadly classify employees as non-exempt to give them the benefit of overtime. So there are very narrow exclusions or reasons that they allow one to be classified as exempt. And as you can see on this slide, there are 3 prongs that must be in place in order to meet that qualification. 1 is a minimum salary. 2 is that you're paid on a salary basis. And 3, that you perform exempt duties as classified under the administrative rules and guidance. These are generally called white-collar exemptions. Let's take a look a little bit about this. First, I think the important element is, because if you don't meet this prong, you don't have to worry about getting to how you pay people or whether they're performing exempt duties under the white-collar exemptions. That's the bottom one there, the exempt requirements. You have to pay somebody a minimum salary, except for outside sales employees. So for that prong, we'll talk about that in a little bit. That's a very important bar to meet first. And before we can even get into the categories of executive and administrative and learned or creative professional and highly compensated. So let's take a look at minimum salary first. Used to be $455 per week or $26,660. Hopefully, all employers have updated because on January 1, 2020, the minimum salary was raised to an annual salary of $35,568. That equates to $684 per week. So very important. If you're not paying somebody that you consider exempt, in other words, somebody who is below the 35,568, that's a problem. They have to be considered a non-exempt, and therefore their hours tracked very carefully to make sure that if they work more than the required hours in a work week, that they're paid time and a half. So this is a threshold that must be met. There is also a highly compensated employee threshold. Anyone making over $107,432 a year can be considered a highly compensated individual and also meet the exempt level requirement. So these are the new minimum requirements as enacted on January 1 by the federal government. Interestingly, when they were looking at the rules, they were talking about some automatic updates. The previous amount of 26,000 was set in the mid-1980s. And of course, some 30 years later, obviously cost of living, inflationary trends, kind of skewed the numbers there, which was why we had to revisit this minimum salary. But the Department of Labor did not put in any type of automatic update, but said that they would update more regularly. Of course, that depends on the political leanings of the administration in charge to be able to determine some of these broad rulemaking authorities. Another provision of the Fair Labor Standards Act is minimum wage. And of course, federal law is $7.25 an hour. However, when a state has a higher minimum wage, you are obligated to pay the higher or more beneficial wage to the employee. So of course, Florida, by constitutional amendment, has instituted its own minimum wage law, which is indexed to the cost of living and inflation and is reset every year. As of January 1, 2020, our Florida minimum wage is $8.56 an hour or $5.54 for tipped employees. So let's take a look and just do a little progress check. So if the federal minimum wage is $7.25 an hour and the state minimum wage is $8.46, what hourly wage is the employer required to pay? Of course, the higher or more beneficial at $8.56 an hour. Now, speaking of Florida state specific laws and our constitutional amendment that instituted the higher minimum wage, I wanted to highlight something that I don't think many employers are aware of, and that is a proposed amendment that will appear on our November general election ballot this year, and that is Amendment 2. Amendment 2 is an initiative to create a $15 minimum wage here in Florida. So anyone voting yes on Amendment 2 is going to be deemed to support the initiative to increase the state's minimum wage. So this will supersede our previous constitutional amendment and establish that $15 minimum wage. Of course, a no vote opposes the initiative to increase the state's minimum wage. Now, the way they're going to, if this amendment passes, the way it will be phased in is that it begins with a $10 minimum wage on September 30th, 2021, and then will increase $1 each year to 2026 to reach that $15 minimum wage. Now, we need a 60% approval rate for constitutional amendments in the state. In 2004, the amendment which raised the state minimum wage from the $7.25 federal rate passed with 71% of the vote to 28% against. So generally we see that these types of amendments have some broad support. I don't know how the current economic conditions will affect this, but as an employer, you may want to be aware. And, if you're troubled by a $15 minimum wage, maybe want to look at your lobbying efforts in that. This can affect the bottom line for many employers if this passes. Just to take a look quickly around the U.S., you can see that there are lots of states which have implemented a higher, kind of the greenish states there, more than half, which have their own higher minimum wage than the federal government. Kind of the yellowy color there is still under federal law. So broadly around the country, we see many of these initiatives pass. Now, one of the other factors I mentioned in the Fair Labor Standards Act is overtime pay. Overtime is an important distinction to be able to make, because all non-exempt employees must be paid overtime pay. Now, by overtime, we're talking about a premium pay of 1.5 times their regular rate of pay for any hour that's worked in excess of 40 hours in a work week. Regular rate of pay includes basic pay plus non-discretionary bonuses, shift premiums, production bonuses, and commissions. So very broadly on their pay. The only thing that wouldn't be considered there would be a discretionary bonus that would be paid. So something not tied to a work or production or some sort of premium. So pay for like unworked hours, small gifts and stuff, generally not included. So let's talk about the work week. So what is a work week then? So we talk about 40 hours in a work week. That's really up to the employer. A work week is defined as any fixed or recurring period of 168 consecutive hours. That's 7 days times 24 hours. So we may begin a work week on any day of the week, but it has to be consistent from week to week for any class of employees. So you can have different work weeks for different sites and our classifications of employees, but they must be consistent for each class or site. So you can see we just have a generic calendar here. One employer may decide to start their work week on Sunday and end on Saturday. That's their fixed 168-hour work week. That's fine. I've seen some employees work for an employer. They may start their work week on a Monday and conclude on a Sunday. Equally, a Thursday to Wednesday. It doesn't really matter as long as you keep it consistent. Let's take a look at how this may impact an employer. So say hypothetically, we have an employer whose work week is Sunday through Saturday, and we have an employee that works 8 hours on Monday and Tuesday, 10 hours on Wednesday and Thursday, and 8 hours on Friday. They've worked a total of 44 hours. Now, this employer pays its employees on a bi-weekly basis. So every 2 weeks, the employee gets a paycheck. So the following week, week 2 of the work week, they work 8 hours on Monday, Tuesday, Wednesday, Thursday. Then the employer realizes, oh gosh, they worked a lot of hours the week before. We'll send them home on Friday at 4 hours. And this way, they're only working 36 hours in week 2. So when you add the two together, it comes up to 80 hours. Well, great. We'll just average 40 hours for week 1, 40 hours for week 2. No overtime would be required, correct? Well, no. Remember, it doesn't matter how you may pay. You know, some employers may pay on a monthly basis, on a bi-weekly basis, every 2 weeks. What matters is the hours worked in one single contiguous 7-day work period. So in this case, even though the employer may have tried to amateurize the work and spread it out over the 2-week period, this employer would be obligated to pay this employee's example of 40 hours of straight time in week 1 and 4 hours of overtime in week 1. The following week, 36 hours of straight time. Okay, so it doesn't matter how you pay them. You can't spread it out over a multi-week period. It's always confined within the 7 days. Here's another example. Let's say we have Memorial Day on a Monday, and the employer has the employee work a couple of hours overtime on Wednesday and Thursday. So, they've worked 36 hours of straight time, and 8 hours are paid for holiday pay. What would be the obligation of the employer in this example? Well, the employer would have to only pay 36 hours of straight time and 8 hours of holiday pay if that's offered. Even though the employee is realizing more than 40 hours because of the couple of hours of overtime, the employer only has to pay on hours worked, not on hours paid. This example for another hypothetical situation, we have Memorial Day and somebody called out sick on Tuesday. So there was 8 hours of sick pay. Again, in this case, even though the employee is being paid more than 40 hours, 8 of them are sick, 8 of them are holiday, and therefore there's no obligation for overtime. However, in week 2, we see the employee probably making up for time, worked a couple of 12-hour days, a total of 52 hours that final week 2. That would require 12 hours of time and a half overtime pay. So remember, no overtime is needed on sick or holiday or vacation, even things like jury duty if they're out for the day or similar compensation. It's only paid on hours worked, not on hours compensated. Now, one of the things that's important to also look at is weekly time records. The wage and hour division, the first thing they're going to come in based on a complaint of a violation is audit your weekly time. If you're a smaller employer and you may not have a record keeping system, a digital system, or electronic timekeeping, make sure that each and every employee is filling out a timesheet. One of the red flags that generally occurs is when an employee, simply puts down, I work from 9 to 5, and every paycheck you see on their timesheet has been correlated to 9 to 5, 9 to 5, 9 to 5. When it's filled out something like that, it becomes a red flag for further investigation. Have employees fill out legitimately the time that they have arrived, the time that they're departing, 9:05, 4:55, however that looks, to be an accurate record, especially for manual types of timesheets. Now, with COVID-19, this takes on new light because you have employees that are working from home. We'll talk about some extensions to the Fair Labor Standards Act, when exactly you have to start paying people. But as an employer, if you have hourly or non-exempt employees working from home, it's critically important that you train them and obligate them to clearly record all the hours they are actually performing work for you, because it's harder to track and supervise when off-site. Now let's talk about some meal and break provisions under the Fair Labor Standards Act. I think many employers and employees, in fact, are surprised to learn that under federal law, there is no requirement for an employer to provide a meal or rest break to an employee. In terms of the wage and hour law, of course, pregnant employees, those that may qualify under the Americans with Disabilities Act, nursing mothers, they may be entitled to additional protections under other laws to step away and have some reasonable accommodations made. But under the wage and hour law strictly, there's no requirement for an employer to provide a meal or rest break. Would I do that? Probably not. I mean, there's obviously good employment practices to attract and retain talent. And, I think some time away from work is always helpful. Some states, like New York, for example, does define when you have to give a meal break for hours worked, how long that is. Florida does not have any such law that addresses meal or rest breaks. Now, if you are an employer that gives an employee a break that lasts 20 minutes or less, under federal law, that rest period, that little break must be compensated. So again, if you're allowing somebody to take a 15 or 20-minute break during the day, maybe an afternoon, maybe in the morning, because it's less than 20 minutes, it has to be compensated. The only meal break that doesn't have to be compensated is one that lasts over 30 minutes. So sometimes we have a quick bite to eat, 15 minutes, go into the employee break room. Again, under 20 minutes compensated. It's over the 30-minute threshold where then you would not have to compensate an employee. Please don't ask me what happens in that kind of gray area between 20 and 30 minutes. Nobody's been able to answer that question for me. But I will tell you the wage and hour division will generally look at anything less than 30 minutes as compensable, even though it's codified as 20. Anything over 30 minutes is where you do not have to pay somebody then for that meal period. So the question also becomes, when do you have to start paying people? So in 1947, Congress passed the Portal to Portal Act. And this was technically an amendment to the Fair Labor Standards Act and helps give us some guidance on when we may start paying an employee. Generally, when we look at the Portal to Portal Act, if the employer restricts an employee's activities and does not allow any personal business, then the hours are included as time worked, including for overtime. So as an employer, you may not be required to pay wages or overtime when the employee is off premises and, let's say, is on call, asked to stay by the phone or the computer or carry a mobile device to respond to if their services are needed. As long as the employee is generally not otherwise restricted. But be careful with that, because many federal courts, district courts, have a different interpretation. And so generally, the more restricted an employee's freedom is, the more likely the time will be considered compensable time. I know some healthcare workers, let's say it may be a radiologist that is on call for a Saturday or Sunday or evening, and they're the one that's going to be contacted should the need arise. And they have to respond to the hospital within a 15 or 20-minute period of being called. That type of restriction has been deemed one where, since the employee is not free to go off and do other activities, that it's limited to a 15 or 20-minute response time. We've seen court decisions where that is compensable time for that on-call type of process. And so we have to look at that analysis. Let's take a look at commuting time and work travel and overtime, especially, when to start paying. As we see with COVID-19 and the requirement of some employers to have their employees wear personal protective equipment, masks, and other types of things, there's a term that we use called donning and duffing. Donning and duffing is, when we're putting something on, donning, and duffing is taking it off. So this gets lumped into things like preparatory and concluding activities. Those are generally compensated activities, whereas some others need not be. The general test is whether these activities are performed solely for the employer's benefit and is an integral and indispensable part of the employee's job activity. So for example, let's go back to the hospital. If I'm a nurse and reporting to shift in scrubs, at home putting on my scrubs is generally not compensable. But working in the OR, where I'm putting on a specific type of gown and sterile clothing, that activity would be compensable. So changing in and out of uniforms is actually a growing litigation issue. Generally speaking, as an employee, they must be paid for changing time if you're required to change in and out of uniform at work. So ordinarily, the employee doesn't have to be paid for changing time if they have the option to wear their uniform to and from work, but may elect to change at work solely for convenience. Equally, an employer doesn't have to pay an employee when the employee arrives at work and is waiting for the workday to begin. That's why some employers have policies that say you can only clock in or start work about 10 minutes before the shift. Some large facilities where a time clock may be at the main door or the administrative area. You want your employees to be able to be at work at the start of their shift. So they clock in and take that 5 or 10 minute walk to their work area. Longer than that can be problematic for record keeping. So be aware though that an employee cannot be doing any casual work without pay during this waiting time. So for example, let's say we have an administrative employee who arrives to work early and who during that time decides to help out another employee or go to their workstation and start performing job-related duties like checking their email, or that may turn non-compensable time into what must be compensated. So going back to your employees who may be working from home, you may want to update your policies and restrict, when an employee is casually checking their email. That may be okay, but if they start responding to email or start thinking about how they're going to address a concern or doing some research, that may be where their shift begins, even if they're not technically on the clock. Similarly, waiting times in the middle of a shift, let's say a machine breaks down, that waiting time would be compensable. Even if the employee reports to work and is sent home for lack of work and performs no work, those are the types of issues that become problematic for an employer. So we have to look at what's fair and predictive in scheduling for the parties. Generally, commuting time is not compensable, of course. However, when the employee is using a company vehicle and they drive that vehicle, let's say it's a plumber or a carpenter or electrician, it's in a company van, it's got all the company equipment and tools, and they're driving from their home to the place of business and receiving their schedule and customers for the day. They start their work week when they leave the premises and start going out. Their commute time from their home to the office is generally not compensable. However, if you have a situation where somebody's in a company van, let's say a plumber, and they're leaving their house and, okay, you're going to 1234 Main Street today, travel time from their home to a customer site in response to the start of their workday or an emergency call or after hours, that would be compensable time. They start their day when they leave their house in the company van. Now, of course, we're in our own personal vehicles. That's different. There's also, under the Portal to Portal Act, restrictions for workday travel. So employees who travel in the course of their workday, let's say from one work location to another, are entitled to compensation for their travel. However, for out-of-town travel, the commuting time, let's say to an airport terminal or where they're going to pick up their mode of transportation, may be considered commuting as if they were going to the office. And so these are complicated issues which, require a lot of analysis before making a decision. And again, the donning and doffing activities we have to look at as well. So I wanted to talk about the Families First Coronavirus Relief Act because this provides some additional pay requirements for an employee. I've talked about this on a previous webinar. So if you have any questions on this, at the end, I'll give you my contact. But essentially, we have to be careful as an employer because through December 31st, 2020, the Families First Coronavirus Response Act provides some additional pay. It's really an expansion of the Family Medical Leave Act to covered employers, to covered employees in their employment situation. So for example, we may have to offer paid sick leave at the employee's regular rate of pay, and that's up to 2 weeks or 80 hours if the employee is unable to come to work because they're quarantined due to a doctor's order and or experiencing COVID-19 symptoms and are seeking medical diagnosis. We also are obligated as an employer to perhaps pay up to 2 weeks at 2/3 the employee's regular rate of pay if the employee is not able to come to work because they're caring for an individual who's subject to quarantine or under the order or advice of a healthcare provider, or they're caring for a child under 18 years of age whose school or childcare provider is closed. We may also have to offer an additional 10 weeks of paid expanded family and medical leave at 2/3 the regular rate of pay, where we're unable to work due to a bona fide leave to care for a child, again, for school or childcare provided issues. So, you know, this becomes part of the notice. You know, you got to post that conspicuous poster in your premises giving notice of the FFCRA requirements to employees. And there's the usual, just like under wage and hour, the prescriptions against discharge, discipline, or discriminating against an employee who takes their leave under the FFCRA, or who files a complaint or institutes a proceeding related to that. And this is pretty broad. When Congress passed this and the president signed it, the paid sick leave and expanded Family Medical Leave Act provisions apply to even small businesses with fewer than 50 employees. However, if you have fewer than 50 employees, you may qualify for an exemption. You want to check very carefully to your legal advisor or your HR department what that exemption may look like. It's not for the quarantine or the active symptoms of COVID-19, but there's an exemption for the leave that's required for school closings or childcare closures as well. So another amendment to the Fair Labor Standards Act is the Equal Pay Act. It was an amendment that prohibits sex-based discrimination. And so it talks about, as an employer, our obligation under the Fair Labor Standards Act to provide equal pay for equal work. Now, jobs may not have similar titles and descriptions, but a court generally looks at the pay as relates to two people doing a job with the same skill, effort, and responsibility under similar working conditions. So the caveat here is that jobs need not be identical, only substantially equal. And I've seen courts view that very broadly. I remember a case one time of a valet where a valet, you know, they paid the valets who were going out and retrieving the cars. It was out in the elements, rain, hot sun, you know, having to run and come back with the, you know, person's car, and, you know, then park a car and run back to the door where they were servicing the client. And most of the workers there were men. They had some women who worked behind the booth, kind of more shielded from the elements, had a little fan going when it was hot. You would come up with your claim ticket, they would get your key and summon a valet over. They were paying those workers, who were mostly women, less than the valets, justifying that the valet's effort was a lot more. Well, it came to the court, and the court looked at, given the overall conditions and the effort, skills, and responsibility, the jobs weren't substantially disparate that it would allow for a disparity in pay. And therefore, that employer was deemed to be violating the Fair Labor Standards Act Equal Pay Amendment in that case. So courts look at, very fact-based decisions on this. And of course, there doesn't have to be an intent to discriminate like that employer to have a violation of the Equal Pay Act. Now, of course, we see some differences in pay, such as for seniority. You may have two teachers working in a public school teaching the same grade level. Mr. Jones is making $8,000 more than Ms. Smith. And that's okay because Mr. Jones has been a teacher for 20 years and Ms. Smith has been a teacher for 2 years. So through, longevity increases and cost of living increases, Mr. Jones is making more. That has nothing to do with sex or gender. It has to do with a factor that is due to seniority. Same thing with merit systems, measuring the quality or quantity of work may be a reason to have a disparity in pay. It's anything as long as it's not based on sex. And this becomes, more significant with the passage of the Lilly-Ledbetter Act, where Congress passed a law that says that the usual 180-day timeline with which one may file a wage and hour claim or other type of discriminatory claim is no longer the case in the condition of a wage and hour equal pay violation. That every time an employer gives an employee a paycheck where it may be a discriminatory violation under the Equal Pay Act, that it renews the clock for somebody to file that. So we're seeing a lot more of these types of claims being filed themselves. So that's a little synopsis of the Fair Labor Standards Act as it relates to current conditions with COVID. I wanted to open it up to a few questions. Before I do, I just wanted to also be able to highlight that there are additional resources that you can avail yourselves to. At the bottom there is my college email address. So if you had any questions or concerns, related to your own business, I can try to answer them very generally. But of course, we have the St. Lucie EDC and the Virtual Business Recovery Center available. And of course, the Florida Small Business Development Center at CCT and CCTI. CCTI offers a lot of training and great instruction for employees, and the SBDC offers some consulting activities. So you may qualify for the availability of having consultants come in and be able to help you. Those are some important contacts then if you want to avail yourself. So I do have some questions. Doreen asked, how does this apply to employers with fewer than 15? So I'm assuming that that question is related to the Families First Coronavirus Relief Act. The law was very broad. In fact, it said it applies to all employers with less than 500 employees. So all employers with less than 500. So 1550, it's going to qualify the Families First Coronavirus Relief Act. So again, the only distinction given that small size of an employer, Doreen, would be if you have certain hardships and essential activities that must be done to exempt you from the requirements for school closure and childcare. But in terms of the mandate to pay, you may want to consult with your legal counsel before denying an employee if they've been quarantined or sent home to care for another or care for themselves. It was a significant temporary extension of the Family Medical Leave Act. And again, these provisions of the FFCRA are in effect until the end of this year, December 31st. Have a question on youth employment. What restrictions are there on youth employment? That's a great question. Child labor provisions under the FLSA are those that are designed to restrict the hours and conditions of employment for minors, to protect kids under 18 from what the law looks at as oppressive employment conditions. So employers are wise to obtain what's called an employment and/or age certificate that's approved by the Wage and Hour Division of the Department of Labor. The certificate's usually issued by the state or the minor school, but broadly speaking, the child labor provisions are designed to protect educational opportunities of youth. So they prohibit employment in jobs that are detrimental to health or physical and mental safety. The FLSA restricts also hours that minors can work and lists the specific hazardous occupations that are too dangerous for youth to perform. So that was a great question. And I think we have one more on white collar. I mentioned white collar. So what specifically would be blue collar types of exemptions? Well, blue collar workers are generally defined as those who perform work that involves repetitive operations with their hands or physical skill and energy. So the Department of Labor has stated that individuals in these positions will never be exempt, no matter how highly compensated they are. So think of mechanics and plumbers and electricians, maintenance workers, production workers, construction workers. These are all the types of positions identified as blue collar. And regardless of the amount of pay that they receive, they would not meet the exempt white collar provisions. So good question there as well. All right, well, I think we're coming up on the hour, Katie, so I want to be respectful of everybody's time. Again, we have the contacts there for anybody that wants some additional follow-up, but it's been my pleasure to present this webinar, and I sincerely appreciate your taking time out of your busy professional and personal lives to attend and understand some of the complexities, not only of the Fair Labor Standards Act in general, but the issues surrounding the additional provisions with the global pandemic of the coronavirus. So thank you very much. And with that, I'll turn it back to Katie.
Thank you, Thom. We greatly appreciate you joining us again this week. And I would like to invite everybody to come back and join us next Wednesday, June 24th at 10 a.m. for our next webinar. We're going to be talking about resilient leadership, thriving through change. You can register for that in advance if you go to youredc.com/VBRC. That's youredc.com/VBRC. Thank you again, Thom, and stay safe.